Well, good evening, everybody, and welcome to another in the 9 Bedford Row webinar series on international criminal law. We've had two previous ones which were very interesting, and I'm pleased to say that the third, exercising universal jurisdiction in a national prosecution, is of interest not only to international criminal lawyers, but national lawyers as well, who may come across universal jurisdiction cases. And several jurisdictions, as we know, do have such prosecutions. This evening, I'm very pleased to be able to present yet another stellar panel. And I've said that every time we've held these, but I've been very pleased to get in touch with old friends and colleagues who've been very kindly agreeable to coming on to our webinar series. First of all, I'll introduce Elies van Sliedregt, who is Professor of International Criminal Law at Leeds University, and she's also an editor of the Leiden Journal of International Law. Her expertise is in terrorism, international criminal law, European criminal law. And Elies and I first met at the Yugoslavia Tribunal quite a few years ago now, but at that stage in her career, she was participating in one of the cases. I'll next introduce Professor Michael Newton, who is the Professor of Practice of Political Science at Vanderbilt University Law School in the US. He recently was in the appeal of the Bemba case and participated in the oral arguments at the ICC. Michael and I have known each other many years, and we've done a few projects together, and it's very nice that you could join us from the US, Michael. A good morning to you. The third of our speakers is Dr. Dove Jacobs, who is a door tenant at 9 Bedford Row. And he is the Assistant Professor of Public International Law and International Criminal Law at Leiden University, and also on the editorial board of the Leiden Journal of International Law, a very prestigious journal. And Dove has recently been an expert at the ICC as well on the Gbagbo case. So good evening to you as well, Dove. Now tonight, as I said, we're discussing exercising universal jurisdiction in a national prosecution. Dove is going to open the evening for us by looking at the distinction between international crimes and universal jurisdiction. Dove, as you know, we keep to our 5 minutes, so thank you very much if you could open this evening.
Thank you, Stephen, and thank you for the kind invitation. Sorry, it's been a long day. It's nice to see so many familiar names, if not faces, out there. I have to make the usual caveat that I'm speaking in my personal capacity and not in any case in the name of the defense teams I'm on or various institutions I'm part of. When I got the invitation, I was wondering, I'm either a perfect or a terrible speaker for this topic, because I've always had very strong feelings about universal jurisdiction, and I've always thought that universal jurisdiction was a nice catchphrase along, other public international law expressions like jus cogens, which are very nice in, advocacy papers, but when you dig into them, don't really cover a very concrete or useful reality in international litigation. And when it comes to universal jurisdiction, for example, I always found it strange that this debate revolved around this concept when you take a very basic approach to jurisdiction, when it comes to prescriptive jurisdiction, essentially states are allowed to do what they want, right? That's a starting point. So states are allowed to adopt universal jurisdiction for virtually anything they want, irrespective of whether it's an international crime or not. So for example, if France tomorrow were to decide that the crime of rape or petty larceny carries universal jurisdiction, it is sovereignly allowed to do so. There is no prohibition under international law for any country to decide that any crime under its domestic criminal law would carry universal jurisdiction. Now, obviously, this would raise a number of problems in terms of enforcement. That's a distinction between prescriptive jurisdiction and enforcement jurisdiction. So in this sense, I always found that the debate about universal jurisdiction about international crimes, and that's a relation to my topic, was a bit skewed from the beginning when we were talking about this topic. What's important to discuss is not so much the question of universal jurisdiction, the abstract term, is a distinction between a right to exercise the universal jurisdiction and a duty to exercise universal jurisdiction. I think that's a more relevant dichotomy because, as I said, when it comes to a right, there's not much international law has to say about that. When it comes to a duty, then we go into more detail into what various treaties or customary law might provide. And even when you get to that second step as a reasoning, in terms of a duty to investigate, for example, international crimes, there is no general rule, contrary to what you might hear sometimes. It's not the same for, if I take the most obvious example where I think there's a kind of cognitive dissonance between what the treaty says and what people claim about it, is the Genocide Convention. The Genocide Convention is one of the narrower jurisdictional obligations, which is just a territorial state. So I'm always very puzzled when I hear claims that the Genocide Convention would provide for universal jurisdiction for the crime of genocide, which is not true. Then you have other crimes where you might consider more adequately that they carry a form of more expansive universal jurisdiction. The most obvious example is grave breaches under the Geneva Conventions or the Torture Convention, which provides a certain number of criteria for jurisdiction, including passive nationality, or the fact that you have to investigate or extradite those accused of torture if they are residing on your territory. The last international crime, I'm being short, just to stick within the 5 minutes, but the last international crime that needs to be mentioned is obviously crimes against humanity. And here, in the absence of a treaty, even though it's being negotiated for many years now, it's difficult to claim, I think, at this stage, that there would be a duty to prosecute crimes against humanity under universal jurisdiction for crimes against humanity. I think the practice, there might be some form of moral/opinion juris about that, but I think the practice is very limited, and I don't think that we can claim this at this point. But I know it's under debate moving forward, and we'll have to see if the Treaty on Crimes Against Humanity ever becomes a legal reality, whether this might change anything in that respect. I think there's just a few introductory remarks on this issue.
Thank you very much, Dove. And we'll turn to Elies now at this stage, where the title was, "Why is Universal Jurisdiction Mired in Legal Controversy?" And I think that was said by Professor Jallow, who is to join the International Commission of Jurists. So, universal jurisdiction mired in legal controversy, Elies, if you could have a look at that for us.
Yes, I think that goes to the early cases we've had with regard to universal jurisdiction, exercising universal jurisdiction. And we had the case of a Belgian prosecutor wanting to prosecute George Bush for alleged war crimes. And we had some very broad, expansive prosecutions with regard to jurisdiction, extraterritorial jurisdiction, with no link to nationality and no link to territoriality in Spain. And these are broad in the sense that they seem to put pressure on diplomatic relations And of course, the attempt to prosecute George Bush is, I think, the best example of that, where we had a whole outcry over universal jurisdiction. I think Henry Kissinger wrote a very critical piece in Foreign Affairs, and a whole debate resulted from that. And eventually, I think the American government threatened to close down NATO in Brussels, the NATO headquarters in Brussels, if this Belgian prosecutor would proceed with prosecuting. So eventually, this broad concept of universal jurisdiction, where you could have an in absentia trials, I should add, so where the defendant wouldn't have to be present, that was curbed, those powers. There was a clear link required, and it's much more difficult now. In a way, there has to be a clear link to the country, to Belgium. So I think that could be a reference by Charles to the controversial nature of it. There's also, and maybe this is a little bit more technical, sort of imposing your normative framework to a person who's a non-national and who's committed crimes abroad. I mean, that's something I'm particularly interested in. And we've had a number of trials in the Netherlands where we had a Dutch court trying an Ethiopian national for war crimes committed in the 1970s when he was not Dutch. He later acquired Dutch nationality, but not at the time of the offences. And can you then, apply Dutch law with regard to those crimes? So these are definitely questions we have no real answers on at the moment, and criminal lawyers are critical of this. And I know one of them is here. I just looked at the list of participants, and I hope you will ask a question about this. So it's more nuanced, if you like, but there's definitely, now that we have more of these trials, and I believe we've had a real increase in universal jurisdiction trials over the last few years. I just looked at a report by Redress, and they said that in 2019, compared to the year before, they had a 40% increase of cases. So it really is happening. And this, of course, was also the idea with international criminal law, that the future of it is domestic. Domestic courts take their responsibilities, and we have to end impunity for those crimes. But there's definitely loose ends and questions to be posed. So these are some issues I'd like to raise. Maybe a last point, and this is more procedural, is are these trials really, can they be dealt with in procedures that we use for garden variety crimes, if you like? So jury trials, for example, are they the best way to try these crimes? I'm thinking about the trial against the ex-wife of Charles Taylor here in this country, where the jury had to listen to days of expert evidence on the conflict, on armed factions, the history of the conflict. And I'd like to hear maybe also from people in the audience what they think about this, but it might be better to just have a panel of judges rather than a jury trial dealing with those cases. And victims, there's certainly in most adversarial systems, there's not really a place for them. And that might be another thing to think about when we want to try these crimes, that, the ordinary procedures might not be fit for purpose. So a few reflections with regard to universal jurisdiction.
Thank you, Elies. Turning to you now, Michael. Elies has referred there to problems in relation to universal jurisdiction. There are problems when a state takes on the responsibility to prosecute something that's thousands of miles away. What are the legal limits we want to look at in terms of universal jurisdiction that you'd like to bring to our attention?
Well, I do think it's appropriate, first and foremost, to say what an honor it is to be with this group, and what a joy it is to see so many people and so many old friends. I mean, I really look forward just to having a discussion among friends. The real legal limits flow from, in a paradoxical way, from the very nature of this debate. That what we're doing, as Dove pointed out, is reaching to international norms, but very few of the treaties actually require. So this is discretionary at the domestic level, both in terms of of the choice of crimes and the choice of suspects, but it's instantiated and it's drawn from the international levels. So this is one of the critical fault lines in the debate. And so for me, the legal limit is to be precise in a non crimen sine lege way of exactly what is the norm that we're prosecuting. When we say war crimes, that's a broad category. You know, and people sometimes get very flippant, very uneven, I would say, in the way they characterize offenses that we want to be universal because of our universal ethos, and yet are at a domestic level embedded in the domestic code in very uneven ways. Some of the domestic codes make specific reference to underlying treaty provisions. Many just speak in terms of offenses that would be subject to felony offenses. The domestic categorizations are all over the map, which I think is a technical, substantive problem. And there's also a bit of a disconnect because what we say is that universal jurisdiction offenses are universally recognized and universally condemned, and yet defined in the domestic codes in any number of ways. The other big legal limit that's associated with that are differing modes of liability. You know, if we really were serious about universal declaration, I'd love to see a greater standardization in terms of the way we think about modes of liability. And there are various ways to do that, either embedded into the conventions themselves or with sort of clearly articulated customary norms. And then the other big thing that strikes me as being, you know, Elies and Dov and everybody on this call, I think, knows that there are political overtones here and a huge amount of domestic prosecutorial discretion. But for me, when we talk about universal jurisdiction offenses instantiated at the domestic level, I think we need to do a better job of ensuring independence and impartiality and the substantive protection of due process norms in those domestic trials. Again, just as with charging practices, it's very, very uneven. And that betrays, to me, a real disconnect with the underlying nature of these offenses. So, and then of course, there's a whole range of practical problems which end up affecting all of these legal categorizations, right? The custody of people, the availability of evidence, the difficulty of having judges who are reaching into international law for the definitions of crimes and for the substance of offenses, but they're having to do it through the filter of oftentimes countervailing domestic norms. And there's always this, it's like, I know I'm old fashioned here, but it's like driving a stick shift car with somebody who really doesn't know how to drive it. There's all of these bumps and technical glitches as we try to take international norms and then embed them into the domestic system. And I think the outer boundary of that can redound in an odd way. Now, on the one hand, it discredits the efficacy of the domestic system. And at the other extreme, there's the real potential for undermining substantive due process rights in a way that takes what should be an admirable process, one that we all agree is necessary, and delegitimizes it and makes it less desirable. So I'd like to see us work on those sort of legal parameters in a way that we have some continuity between the concept of a universal crime that's universally condemned and the evenness and the normative regularity of enforcement at the domestic level. And there's much more to say, but you know, with a panel of a powerhouse panel and a wonderful group of participants, I just really look forward to a good discussion.
Thank you, Mike. Just looking at the problems then, and Elies referred to Bush case in Belgium. Is there a danger that these universal jurisdiction cases become political cases, so that what is being sought to be done is to politicize the legal process?
Can I just respond briefly, Stephen?
Yeah, okay, Elies, yeah.
Okay, yeah, no, I just wanted to mention, I forgot to mention in the introduction, that one of the things that we encountered in the Netherlands was brought about by a prosecution of Tamil tigers, where the court, so these were prosecuted for terrorism and complicity in terrorism. Eventually the court, they were convicted and they were sentenced, but it was interesting in the sentencing, the court felt that they wanted to be nuanced in imposing a sentence because they felt that they'd only seen one side of the conflict. And if you bear in mind that, of course, there's been a real push to have the Sri Lankan government deal with the crimes basically also committed on their part in putting an end to the civil war they had, that there's been real demand by the international community to set up a UN tribunal, or at least, you know, to try these people. What you now have is that those who fled the country, Tamil tigers mainly, LTTE people, are being tried in Denmark, in the UK, in the Netherlands, and you only get to see one side of the conflict. So that's another side of the politics of universal jurisdiction, if you like, that I'd just like to highlight. And in a way, it just reminds me of the one-sidedness we had with the ICC on those self-referrals, where you've got governments sort of conveniently outsourcing prosecutions. And in a way, you get that with domestic trials as well, when you deal with extraterritorial powers.
Yeah, so if I can just turn to you, Dove, about the point Elies raised there, where you get the national prosecution that is being used against one side, and the jurisdiction itself is not in control of the conflict. It's not viewing both sides. It's not in receipt, presumably, of evidence from both sides. And there you've got a Dutch court recognizing this. Perhaps Elies will tell us later how the prosecution came about, whether there was political pressure for it. But Dove, do you have some observations then about these types of cases?
Actually, listening to Elies and Mike, I was struck by the fact that, you know, a lot of the comments one can make about universal jurisdiction cases, we can generally make about international justice. You know, the kind of lack of proximity to the crimes, and Elies just mentions the one-sidedness of prosecutions, and you know, the challenges to due process, the lack of access to evidence, and I think it's very difficult to compartmentalize the types of, you know, justice mechanisms we have, because essentially there's only two types of mechanisms, either local or not. You know, if that's our starting point, and a lot of people agree in you know, the past years, 15, 20 years, about the benefits of transitional justice mechanisms with their downsides, but anything that's not local will face those challenges, whether it's universal jurisdiction in the Netherlands or Germany, or whether it's ICC when it comes to access to evidence. And it's the same about politics. The fact is that those cases which relate to international crimes, those crimes occur in an inherently political context. You know, so the idea that those trials could be anything but political, I think, is a fiction. The question is, how do we deal with the politics of the situation in the judicial process? Sorry, because I think it's unavoidable that politics will seep in, whether it's in charging policy, whether, you know, just the prosecutor defining a crime as a crime against humanity, was it a war crime, is already taking a side, a narrative side. It's not the same story you're saying about how you understand the conflict. The fact that some political actors locally will use the trial for political gain is unavoidable. We can't avoid that. You know, it's going to happen. So I think, and again, that applies whether it's a universal jurisdiction case or the ICC case, whether, you know, we can mention virtually all situations at the ICC, which, even if they've been dealt with adequately from a legal perspective, will be used as a PR tool by different sides of the conflict.
Yeah, can I add to that, Stephen, though? I mean,
Yep.
I love what Doug just said, because what he's putting his finger back on, or shining the flashlight back on, this disconnect between a universal prescriptive jurisdiction and all of the literature and the sentiments of people who, you know, universally condemn, and the definitions of these, the contours of these crimes as a matter of international law, and then the appropriate exercise of prosecutorial discretion in adjudicative jurisdiction. The difficulty in these cases is that many times, as Dove said, they're inherently political for lots of reasons. And let's be fair, there have been times where that prosecutorial discretion has either been misused or attempted to be misused in a way that exacerbates that problem. So I think all the lawyers in this group that are really good faith practitioners don't want to throw the baby out with the bathwater. We want to see regularity. We want to see some normative consistency where you have the proper exercise of prosecutorial discretion at the domestic level because there's plenty of crimes and there's plenty of offenses to go around. And you know, one of the missing things in this debate is mutual legal assistance treaties pursuant to a lot of the conventional structures that do help us get at evidence and assistance between prosecutions. And what tends to hinder that is, in fact, the political nature of these things. It's like the sand and the grit, the wheels of the system, because of the political nature that ends up undercutting the ability to collect evidence and facilitate cooperation across international boundaries. And I think that's a big practical problem in the field.
Elies, in terms of laws, international law is clearly defined at the International Criminal Courts. And since Sliedregt now, we have a framework that broadly we understand where cases fall and what the types of cases that are going to end up at either the ICC or at an ad hoc tribunal. And those are laws that have been developed. In relation to the national jurisdictions, though, they don't have that same experience because jurisdiction has tended to follow sovereignty and national laws, but we're dealing with international crimes here and crimes of so-called universal jurisdiction. What sort of problem does that throw up?
Well, so there are a number of states who will have incorporated in their statutes international crime definitions from the ICC statute, certainly member states, many of them have. Others might not have, but many will have something that incorporates the Geneva Conventions. But even those who have really sophisticated International Crimes Acts statutes might still have questions around which modes of liability do you apply. And it was already mentioned by Mike, who suggested we should have some sort of a framework with an international, understanding of what modes of liability apply to these crimes. And that is really where there's a lot of questions. I mean, we had this in the Netherlands, again, sorry to mention my country a lot, but we've had quite a number of cases. And we had this case, I'm sure you're familiar with it, of the Dutch businessman, Frans van Anderaat, who was prosecuted for complicity in genocide and complicity in war crimes. And for the complicity in genocide charges, he was eventually acquitted, the first instance, because the court said, well, with regard to complicity in genocide, we have to apply a very strict standard of knowledge, which is not the Dutch standard, the ordinary standard under criminal law, but because it is genocide, it's an international crime, if we would use this very broad concept of dolus eventualis, of recklessness, type of recklessness, that would water down the international crime definition, and therefore we can't apply that, and he was acquitted of it. So it really can be a question of guilt and innocence, if you like. And he was eventually then convicted for complicity in war crimes, which was endorsed on appeal. But the question really is, yes, I mean, at the moment, I don't think the international standards are very clear around modes of liability. And we just had a case at the ICC with 4 separate opinions and 1 concurring opinion on 1 mode of liability, and that's the appellate court. And you just think, what's happening? So yes, we can rely on national law with regard to modes of liability, but it does require, I think, the judges to really almost be experts in international criminal law, because with regard to the crime definitions, because they are exercising universal jurisdiction, to me, that means that they have to apply international jurisprudence and case law, interpreting those definitions. And same with command responsibility, by the way, which is this concept which really has a clear international pedigree. I would argue that also with regard to that, domestic judges would have to be guided by international case law on that. So yeah, it's asking quite a lot from panels dealing with those crimes.
Yeah, Dove, would you like to contribute to that?
No, actually, if I may abuse your position, Stephen, and ask a question to Elies, and maybe
Sure.
why should, I mean, I know it's a kind of common sense idea that we have to avoid fragmentation, etc., but I want to challenge what you just said. You know, domestic laws are domestic laws. And if France wants to have a different definition of genocide, which it does, than Germany or than Sweden or Syria or, you know, Belgium, what's the problem? You know, the fact that these laws might be inspired by international criminal law, but I do not see an inherent you know, obligation or necessity for every state in the world to be, I mean, even putting aside the fact that international judges might not be as expert in ICL as you would want them to, that's a different problem. But even assuming that there is this group of experts who actually know what they're doing, why should every domestic system have the same modes of liability, the same criminal law?
I'm teaching the École Nationale de Magistrature tomorrow, so let's see where we go. No, I agree with you. So, but there's a few things we need to unpack here, I think. So first of all, if you're exercising universal jurisdiction, I would argue that means that that's with regard to international crimes, and that, you know, mandates you to apply international law. And I think you can take this from the Lotus case that was argued there. I don't have the specific, I was looking for the quotation, but I think it's in there that there's a reference to that. Now, with regard to modes of liability, I would, like you, be more nuanced. And I would say just apply your national law, which is, you know, developed over centuries. It's clear, it's not so muddled with some concepts that we have in the international arena. And maybe, I mean, the question also is with regard to French nationals, you might be able to exercise a much broader concept of genocide, which is, you know, under French law, the definition of genocide. But the question is, can you do that with regard to non-nationals who've committed crimes abroad? And I think that's where you get into difficult situations.
Yeah, to answer Dove here, I mean, if you're prosecuting something that happened out with your jurisdiction, so it's not within your borders, your territory, and it is at the time and place where the events took place, the individual was subject to a different regime, a different perception of the law. Is it right to impose out with that jurisdiction a separate code of conduct, or a code of conduct he was unaware of? Doesn't that offend many principles of basic law? Mike, what's your feeling about it?
Well, I mean, I think they're good arguments on both sides, because both these people are my friends. But I do think that there's a real problem of overclaiming here. When we say, okay, we agree, for example, just pick one out of the air, the crime against humanity of persecution is universally condemned. And therefore, to take your point, established by customary international law and universally prescribed, et cetera, that's going to look very different in the domestic systems of countries around the world. And so where you are, I think we need to be very careful not to overclaim. You know, the other example, of course, is the big field of war crimes. You know, which pieces are precisely defined, as you point out, not just by the relevant treaties, which of course have the limitation of only being applicable to those treaty parties, but really truly defined as a matter of binding customary international law in a prescriptive way and therefore enforceable. I think there's a real tendency here to overclaim, which gets back to the earlier point of why do we do that? Politics, pressure, you know, sometimes a biased exercise of prosecutorial discretion, which delegitimizes, that tends to actually, to take Dove's point, lead to more fragmentation. And in a way that undermines the efficacy of the larger norms. So, I mean, I think these are important debates to keep having, but we don't need to be shy about saying, you know, here what we're talking about is this really sophisticated merger of international and domestic in terms of all these things, the definitions of crimes, the modes of liability, the substantive due process rights, rights of the defense for disclosure, even things as basic as proofing of witnesses, where there's going to be wide variations across systems. When we say universal, it doesn't mean a homogeneous template across systems.
Yeah.
Stephen, if I may take a stab at your question, actually, it's obviously I agree with you. And as you know, I've written a lot and way too much on the principle of legality. And I have probably one of the most extreme views on this issue out there. I'm not alone, but I even challenge the opportunity of using customary law as a source of international criminal law, because for me, it inherently violates the principle of legality. And the idea that this whole ICTY logic that if it's customary law somewhere, it's fine. It doesn't violate the principle of legality. Even if you take the ECHR case law and Kononov and others, I find them very unconvincing, because the idea that you have to, when it takes judges 300 pages and dozens of research assistants to dig up what some war manual must have said somewhere, and you expect a defendant in a forest in Latvia to have known what the law was, I find that laughable. But it's not the same problem as the idea of uniformity. I think you're absolutely right on the question of principle of legality here, but it doesn't mean that it's a different argument than the one where you would say that for the sake of uniformity, we should all states in the world should apply the same laws and should apply the same modes of liability. I think it's two different problems, but I perfectly agree with the due process and rights of the accused issue.
Just to mention to everyone, the chat line is open for any questions that you want to send in, and I'll pick them up as the discussion continues. I see I can't spell chat very well when I'm typing and listening at the same time, but there we are. I think you understand me. Elies, the modes of liability point that you made is a significant one, because if conduct is taking place elsewhere, to impose a different standard of conduct than the one that would have applied under universal jurisdiction is surely unfair.
Yeah, I find that a tricky one. So you could argue indeed it violates the principle of legality because there was no foreseeability. There is also, of course, the argument that, well, the principle of legality plays a different role in international criminal law. Engaging with a regime that commits serious human rights violations, it's clear to everyone that you should not do that. And the whole foreseeability argument is a bit of a smokescreen. And I have to say, I actually agree with that. And it does mean that you are indeed imposing maybe norms on an individual with regard to modes of liability, at least, which were not known to the person at the time. He or she was not subject to those because he was not national and not a national of that country. But yeah, I mean, that's the way it is. At least the crime definition applies. And as I said, the foreseeability argument, I don't find it that persuasive. It's more, I think, the question of legitimacy. Can you impose your particular normative framework on another individual who's not linked to you in any way? And that then goes to the title upon which you act. You exercise jurisdiction, which is an international one. And I have no real problem. I mean, I've thought long and hard about this, but I know there are definitely good arguments against it. But I don't see why this is such a problem for foreseeability. And with DOV, okay, the whole customary international law, this survey, sort of this harvesting of general principles of criminal law, what international tribunals and courts do, and trying to argue that this was a well-established principle or whatever. To me, it's always been something more for legitimacy of the court, because they operate in constitutional limbos, really, and it's not so much the foreseeability argument. I think it's more about can we do this? Do we have the power to expand our statute by interpreting this norm this way? So that's how I tend to look at that. But yeah, it is definitely a valid question. But in the Ethiopian case, where the particular individual was tried before Dutch court, he had acquired Dutch nationality. So at the time of the prosecution, he was Dutch. So then I think it's already more nuanced. And also, I think he was in absentia tried by an Ethiopian court and sentenced to death. So he was in a way better off here. But yeah, maybe you could do something like applying the Lex Meteor rule. So in terms of looking in the sentencing, if a person would have been tried by a local court, would that have resulted in a more lenient sentence? Maybe then the court should look at that, take that on board. But yeah, it's still something I'm struggling with, as you can hear.
Yes, I mean, sentencing is one thing, but criminal conduct as well is another. And let's just look at the questions now. Brianne is really enjoying it. Glad that's so, Brianne, and would like to know the views of the panel on the European dominance in bringing universal jurisdiction cases, whether that's a problem. And many commentators have said that this is a Western states, European conversation, essentially, about universal jurisdiction. How universal is it then? And how do you apply those European standards which you're seeking to impose when perhaps the conduct is in Sri Lanka thousands of miles away? What's the thoughts about the European dominance of this area of law and jurisprudence? Mike?
Well, I mean, I think the European cases, particularly recently out of Syria, have gotten more publicity because those people are there and therefore, able to be brought before those jurisdictions. But we've done plenty in the United States too. Charles Taylor's son, Chucky Taylor, universal jurisdiction case, and our own statutory implementation of the Torture Victims Protection Act. It's just not common here. I think one of the things you run into, at least in the United States, is this definitional issue, because what you've done is you're tightly constrained by the applicable statutes, which in some cases simply mirror. This gets back to the debate about, are we reaching into custom or are we reaching into binding treaty obligations? But for me, I'm not particularly troubled between the United States and Europe. It is a more difficult point in terms of universal jurisdiction cases raised in Latin America and raised across Africa. And this is an area where, to the extent that we're troubled at the uneven enforcement, we do a better job of building cases and taking cases to prosecutors. I think in those capacities, a lot of time it just comes down to the pragmatic difficulties of having the evidence, having the accused, being able to run a trial. To be flippant about it, these people are in Western countries, and therefore we have more opportunity to prosecute them when we can. But where that's not true, I think we do owe domestic prosecutors some assistance. I mean, we worked with Ugandan prosecutors, we worked with prosecutors in Latin America, and I just think to the extent that we share universal condemnation of these acts, then as a legal profession, we do a better job of helping each other investigate them and prosecute them.
Yeah, the next question from Tamas is universal jurisdiction and the crime of aggression, which as a discussion topic. Dove, do you have any thoughts about that? We now have the crime of aggression.
Well,
any thoughts?
I mean, not specifically on the universal jurisdiction aspect, but to the extent that we buy into the argument of the link between universal jurisdiction and customary law, I think there's a major problem with the crime of aggression, because I actually did my master's thesis on the crime of aggression before Kampala, and I called it the sheep in the box. For those who have read Le Petit Prince, The Little Prince, if you recall that story, the little prince asks the pilot to draw him a sheep, and the first sheep he doesn't like, the second sheep he doesn't like, and the third time the pilot draws a box. and puts 3 little holes in it. And the little boy says, "What is this?" And he says, "Well, the sheep you want is in there." So we don't actually see a sheep. And I always was struck by the discussions on the crime of aggression for so many years where everybody was claiming that it was customary law, but nobody agreed on a definition. And quite naively, I always wondered how that was possible. If you can claim something's customary law, you must be able to define it. So in terms of both definition and practice, I think that I would say that at this stage, there was very little evidence to suggest that there would be universal jurisdiction in relation to the crime of aggression. I think that even though this is the typical crime of Nuremberg and everybody's talking about it for the past 70 years, I think that it would be a stretch to claim that there would be any obligation under international law to prosecute aggression as a universal jurisdiction crime.
Thoughts on that, Elies? And maybe it's one the Netherlands hasn't tried yet, but I dare say that there may be some attempts. What are your thoughts about it?
No, I would agree with Dov. I don't think there is a clear international duty to prosecute aggression, and I don't think a Dutch court is keen on doing it either. Just to go back to the previous one, if I may, with regard to, oh gosh, now it goes again. What was it again? Do you remember, Stephen?
The European dominance in bringing...
Oh yeah, because I just wanted to, not really maybe an answer to the question, but I think at the moment, quite a number of NGOs are actually using these European channels, if you like, to argue cases that deal with victims of the Global South. So the European system, if you like, is used to draw attention to many of the violations that have happened in those countries, and victims have no justice and no access to justice in those countries. So so I think in that sense, European dominance, if you like, on the international criminal law stage is probably a good thing. It does beg the question, how this is going to go on, in terms of where do these campaigns end up? How do they choose their jurisdictions? I mean, they've got really sophisticated ways of looking at this, and I'm curious to follow these actions. But at the moment, you actually see that the European stage is very much used to end many of the crimes happening in those countries. So just wanted to add that. But with regard to aggression, I just don't think there's a duty, and let's not go there.
What you were referring to there as well is really forum shopping.
Yeah.
Mike mentioned the Torture Victim Prevention Act in the US, which is a civil act, not a criminal act. So it gives a rise to civil liability, very different from criminal law. But you've got forum shopping, and in civil law, often forum shopping bars your case. And it leads to tenuous links as a result of the shopping. What are your thoughts on that? Is the Netherlands being used in that way?
Yeah, there are some activist lawyers, to use that term, who cooperate closely with NGOs, and they have indeed brought cases to the attention of prosecutors. But more recently, I think prosecutors have been a little bit more picky in which cases they will go after, because of course they have the discretion. They don't have to prosecute, unlike some other countries. And the policy seems to be very much now to go after those where there's, where the evidence is closer to home, Dutch businesses, Dutch nationals, and if they are non-Dutch or acquired Dutch nationality later in life, then there may be another state, the locus delicti, which is more appropriate, and then they're very happy to cooperate in criminal matters. So that seems to be now more of a strategy. And certainly that's what we saw with Rwanda. Not many cases now of Rwandans before Dutch courts.
Right. Yeah. Let's look at some more of the questions that have come in. I won't be able to do all of them, but let's try with the next one from Roberta. Problems not only lie with domestic judges, but also with domestic prosecutors, I'm afraid. The matter has been complicated by the current trend to mix ICL with anti-terrorism legislation. And I know, Elies, that's one of your specialist areas at Leeds. What are your thoughts to Roberta's question there?
So I'm not sure. I really, the mix between terrorism and probably war crimes law is definitely something I can imagine prosecutors get into. And the Sri Lankan case, for example, there's a whole argument around whether these people, the Tamil Tigers, were combatants or not. But I was quite surprised by the expertise by prosecutor, but also the court. They they do have this specialist knowledge to make the distinctions, to rely on the international sources. I can't speak for other courts because I've not seen sufficient case law on that. But these are tricky legal issues. Yes, I'm sure that with prosecutors, the problem of not really getting the law right is very real. I think a number of countries, mainly European member countries, will have set up specialist prosecutor offices. This country, unfortunately, has not yet really done that. And a certain expertise, I think, is just necessary for dealing with those cases of universal jurisdiction. And the Netherlands certainly has a very good group of people looking into these cases, real experts, colleagues of ours, people that we know and go to conferences with. So, yeah.
Yeah, with Mike, that expertise and having a specialist group to deal with war crimes cases, universal jurisdiction cases. We know we have the US ambassador at large for war crimes, and you've been a special advisor, as I remember, in relation to various ambassadors who've had that role. Do you think that's important for national prosecutions to be able to carry out this type of work?
Oh, I think it's vitally important, and I'm glad you gave me the chance. I saw a comment from Bill. Yeah, Chucky Taylor, I mentioned, was a U.S. citizen, but all the crimes were extraterritorial, didn't involve U.S. citizens, which goes back to my earlier point. I think there's a big disconnect in the way we take international norms and put them into our domestic statutes, both in terms of the technical expertise and, as I mentioned, the modes of liability. I do think universal jurisdiction, we tend to think of it purely in the criminal sense, but there's also lots of, if you will, cross-fertilization. I was just consulted not too long ago, for example, on a case in the immigration context of somebody who had been in and around Srebrenica and was, had answered the immigration question, have you ever been around genocide? And he said, no, I didn't have anything to do with it. And in resolving that case, in terms of extradition, or in some cases just simple removal, deportation, they're drawing on the international norms, both the technical substantive definitions, but also modes of liability. I wish we did have a more standardized place both at the domestic system and in the international system for the real expertise to get out to advise judges. It's just, we're not there yet. And I think in the early days of the field, we could say, well, yeah, it's a new field. There's just not enough development here. We're well past that at this point, where we should have maybe the IBA, I don't know, but a much easier way for judges to reach out for assistance on these very technical issues of precisely identifying the gaps in the law and exactly what the legal issue is, which is a way of saying to a judge, what facts are really relevant here? And how do I take this set of facts and weigh them against a mode of liability or a substantive crime in order to build the strongest case? And remember, the undercurrent of every bit of this is the politicization and the legitimization. So, I mean, I agree with Dove. I don't want absolute uniformity across systems, but the outer boundary on that is delegitimization and just political ad hocery. And that's a problem for me.
Taking Roberta's question, Judge Jav here, You get deviations between the ICC and ICTY on standards to be applied. What do you think the national judges should do in such circumstances, weighing up as between the ICTY and the ICC?
Well, given my starting point, which is my difficulty in accepting customary law as a source of ICL, whether it's on the definition of crimes or modes of liability, I have difficulty answering that question. But I think this is a very good question in showing the difficulty in identifying the actual content of customary law, because one of the issues when it comes to customary law in ICL is the kind of tension between legality and progressiveness, or human rights progressiveness, or victim-centered approach. And we see that time and again in the case law of international tribunals, where you'll have this tension between some judges who will put forward a more reasonable view on the principle of legality, and judges who will say we need to expand this for the victims, for the fight against impunity. And I think that this is a tension you have in a number of points. If you take the organizational policy in relation to crimes against humanity, the ICC Rome Statute put it back in. The ICTY had rejected it. Where's customary law on this right now? Honestly, I don't know, because the ICTY case law is pretty settled on that matter, but the Rome Statute is kind of a big thing. It's not a minor document, and so claims that the states in Rome kind of rejected, deviated from customary law, and we should ignore it, I think is a difficult proposition to make. It's the same with modes of liability. I mean, the specific direction debate at the ICTY, when you see how the Senovich appeals chamber kind of threw it in the garbage, and the way they dealt with Article 25.3c, which seems to suggest to some extent a specific direction, they say, well, it's just the Rome Statute. It's not necessarily customary law. Let's set it aside. So it's really, and Mike was using the term consistency before. I think that's a real problem here. The consistency depends on the kind of teleological approach on what will best fight against impunity, what will best expand the definition of crimes. And I don't think that's good legal methodology. I think that's, just, sorry to use the term, just natural law in other terms. It's not positivism. And so I think it's a very difficult question to answer, essentially.
But you have so many more decisions from the ICTY and ICTR. They have a back catalogue of decisions and jurisprudence stretching over many years and many more cases than the ICC.
Yeah, but if I may, the difference is that the ICTY, you had this vague reference to customary law, but essentially it's a handful of judges inventing the stuff as they went along. And I'm sorry, I can see who's in the audience, and I don't mean any disrespect, but the whole system is that, whereas the Rome Statute is negotiate whatever one thinks of diplomacy and state negotiation. I think that the Rome Statute, whatever one thinks of it, is a much stronger evidence of opinio juris than a handful of judges in the appeals chamber of the ICTY inventing customary law as they went along. Again, no disrespect.
Yeah, Elies.
Yeah, I would agree with Doc. Sorry. The ICC. Yeah. Did you want to give somebody else the floor? Happy to concede.
No. Please respond, Elies. Okay. I could see
No, I agree with Dov. I think the ICC is probably the best framework to follow as a domestic judge. It's the only one left in town. It has that gravitas, if you like, as an institution based on a treaty, which has been negotiated over years. I just hope that the ICC judges interpret their statute as much as they can in the spirit of the ad hoc tribunal case law, because that was problematic in the beginning of the ICC's life cycle, that it felt very much it had to do something different. It was new. I didn't have to look at all this jurisprudence. That made no sense, I think. And that has changed, and that's a good thing, if only indeed to limit the pluralism at the international level, so that domestic judges have something to really work with.
Yeah, Mike.
Can I add to that though, Stephen?
Yes, please.
Having negotiated the ICC elements of crimes for those countries that have just taken the Rome Statute offenses and domesticated them, which is not an inconsequential number of states, influential states, but far from complete. Many, many other states are either very selective in drawing out of the conventions into their domestic law, or make very broad reference to fields of criminality. And I just think it's worth pointing out that this remains a big problem, even in the states, and this being this distinction between treaty norms and where do we pick from the jurisprudence. Everything from, okay, nobody's going to argue that genocide is not a universal jurisdiction offense today. You're going to get very little argument on that. How do we define the group? What's the difference between an ethnic group and a religious group? How do we define the characteristics of the group? There's lots of subordinate questions that become vital, getting back to truly determining the precise legal basis for those set of offenses in the domestic system. So, I mean, this is where I think we have to be very careful and very conscientious to work through the details here, rather than, Dove points out the broad teleological, we want to get all the bad people. Well, sure we do, but we're the technical lawyers, we're the technical experts, and we've got to be careful that we don't fall prey or allow courts to fall prey to this very broad framing, that we do it with some technical accuracy and precision. And that's why I use the word consistency, because I really would like to see us, be disciplined in that and ask the hard questions and force courts to answer the hard questions.
Yeah, how do judges get this training though? Because the issues we're raising here are outside national jurisdiction norms, and the experience of the cases at the ICTY, ICTR, ICC have shown there's a lot of jurisprudence that's developed, but we're talking about a very small spread of universal jurisdiction cases. How do judges acquire this kind of expertise when it's outside their normal purview?
They invite Elies to teach.
That's it. That's the answer to everything. No, I do think there's something to be said for a specialist court dealing with these crimes. So like you have specialist prosecutors dealing with serious crimes and courts dealing with serious crimes. You can have a chamber within a criminal court dealing with international crimes. And I know a number of countries have that. They will generally also deal with other international criminal law, so the transnational type, and with European arrest warrants, etc. But there's something to be said, because it does require a certain expertise. I agree with you, Stephen. It is not an easy area. You can't just, do these cases alongside your normal practice.
I think, if I may add something to that, we often focus, and rightly so, on the definition, the technical definitions of crimes and modes of liability. But I think the training that is lacking, and it's more complicated, is actual expertise in what is an international investigation. What is the type of evidence you gather? What does it mean to interview witnesses in a conflict zone, or to get prior recorded testimony in a conflict zone? Issues of credibility, authenticity, political context, narrative. I think that we kind of don't insist enough on that, and I think in a lot of those universal jurisdiction crimes, if you take the cases in the Rwanda cases in France, of course, the judges might sometimes show lack of understanding of the definition of genocide, but what they mostly show is lack of understanding of the context in which some witnesses are being, shuttled over by the current government to spit out pre-decided testimony, and they have no clue. So I think we should also focus on those very practical aspects in terms of training judges in a domestic context.
Yeah, international lawyers approach this very differently from their national cases. They're aware of the evidential problems that you get in cases. Mike, you were going to say something there.
Well, I'm tempted to say here, here, and stop, but I'll give another example. Here, dossier evidence. Why, when I take a dossier and I put it into evidence and I start to look at probative value, funny thing that that, you know, it's creating a narrative and it's reinforcing a narrative, and the ability of judges to look past that and see either the counter narrative, whether or not that counter narrative is offered by counsel. That's the point, is that the prosecution bears the burden of proof at the, of course, we all know this. But Dove's right. These cases are incredibly complex in the actual adjudication. And it's not enough to say, well, these are universal offenses. They're universally condemned. The normative standards come from international law, and we all need to work together at the domestic level to enforce them. It's far more complicated than that and nuanced. And that, I think, again, I'll say it, feeds back into the perception of manipulation and delegitimacy for the things that we want to be totally legitimate. That's the paradox in this field.
Yeah, Elies, I mean, that's an important point, isn't it, concerning these national prosecutions, say in Holland, that you took as an example, where the place where the evidence arises may carry with it a load of problems and the production of evidence that is very different from how the national case comes about. And you've had experience of working at the ICTY, that kind of different background and understanding about the sources of evidence and reliability. How do national cases, how do national prosecutors, national courts really understand the background to a case?
Yes, very valid point and question. I think you live and learn through, I mean, trial and error, isn't it? We had a case with another Dutch businessman who was tried for war crimes, complicity war crimes, because he was dealing with Charles Taylor, basically, and through his timber company, providing him with weapons, etc. And he was tried in the Netherlands. His defense counsel was really poking holes in the prosecutor's evidence with regards to witness evidence that was very unclear, because you had to, you know, they were dealing with people from West Africa with different cultural backgrounds, never been outside of the country, and different ways of thinking about, you know, temporal value. And they were not allowed, the defense, to hear witnesses or to really pursue that line of poking holes in the prosecutor's evidence, because, as you know, the Netherlands is not an adversarial system and it is a lot on the dossier. And eventually that he was convicted, and that was turned round. So the Supreme Court eventually referred the case back to the Court of Appeal to, with the instruction, listen to these witnesses and let the defense argue her points. And so, yes, I think they really had to, be confronted with this problem of cultural differences, and you have to allow witnesses to come to court. And it's not in our tradition. So we have a lot of the witness hearings beforehand done under the sort of supervision of the prosecutor. And then you've got the dossier and you deal with it on trial. But that has changed a bit, that's shifted a bit because of the specifics of these cases, because of the cultural language barriers, etc. So that's one thing. The other thing was allowing the defense to actually go to the country and also question witnesses herself. So Lisbeth Zegveld, a colleague of ours, very prominent in this area, was initially in a case of an Afghan national not allowed to go out to Afghanistan and question, look for witnesses and talk to people, and really found it impossible. There was no insurance, practical things like this. And that has changed because she insisted, and eventually it was equality of arms. That argument, of course, was made, and successfully. So yes, these are cases that are very different from any garden variety type of crime, criminal case. And you would hope that courts are sensitive to that and allow the parties to do the best in defending their client or prosecuting their case.
Yeah, Dove, I mean, you were in the Bagbo case, the problems of the evidence gathering in that particular case is well documented. and the, the faults in the lines of evidence and the framing of the case and the concept of the prosecution apparent. A national prosecution, would it understand as well those kinds of problems, do you think, which an international court faces?
So there are actually several questions in your question. I mean, just to point on the Bagbo case, I've always resisted the idea that the failure of the case is due to bad investigation. I think the failure of the case is having decided to go to trial with bad evidence. You know, if this, because that, no, but just to make that point is that, you know, it's not this kind of idea, not from you, Stephen, but it's just making me think about it. There's always this underlying suggestion that if the prosecutor had been more competent, they would have found the evidence and they would have convicted. And there's never any, never in that reasoning is there's the idea that maybe the evidence was just not there. So I just wanted to make this, it's always this assumption in that respect. I'm not very optimistic. I do believe that investigating international crimes is a complicated affair, and I don't think that even the most competent investigator, domestic investigator, will be able to grasp the context, gather the evidence in a way that will allow for an adversarial process with equality of arms. I mean, Elies was mentioning the Netherlands. Similar issues arise in France, obviously, which has the same system, where the defense is basically told, here's a dossier, you don't need to investigate. We've done the investigations for you. We've interviewed the witnesses for you. You're not allowed to go to Rwanda or wherever. So I think that, I'm quite, I don't know who mentioned, I think Elies mentioned, not making it her own thought, but the idea that universal jurisdiction was the future of international justice. I don't think so. I think that we like the idea, but that the difficulties that we're facing at the ICC will just be tenfold when it comes to universal jurisdiction cases. And of course, we have a handful of successes where the stars are aligned in terms of evidence and having the witnesses, the victims who recognize the perpetrator in the streets, in Germany. But I think if putting all our hopes on universal jurisdiction is probably a mistake in that sense, and that the issues of gathering evidence and building cases will not just go away.
Yeah, we had a big war crimes case in the UK in the 90s involving the Second World War, and it always concerned me about the gap in time. And the Act was passed, I think, in 1989. Around then may have been 1988, and then it was retrospectively looking back to the Second World War. And it seriously concerned me at the time about going that far back and being able to properly deal with evidence. It's not good enough just to say, oh, well, you've got to do your best and that's the best in the circumstances. It is about overall fairness. Are those historic cases in Holland that you've been talking about, Elies?
No, not really. We don't have Second World War cases anymore. The last one, I think, was in the 1970s. But no, these are real problems. Yeah. And I think that's, universal jurisdiction trials, to go also back to what Dov said about he doesn't think it's the future. I think we have a role as domestic jurisdictions to end impunity, and it's really those signed up to the ICC have basically taken on that duty. It's difficult, yes, and these trials are very expensive, they require a lot of expertise, and at some point there may be valid questions also from citizens and taxpayers, is that what we pay our money for? We want police in the streets rather than these expensive trials with regard to one individual decades ago outside of our country. But and what you now see, and you see it especially in Canada, but also in the Netherlands, it's happening, is that through the immigration system, people are excluded and thrown out of the country, basically. And so you don't even get to the stage of a trial. You basically exclude a person, which you can validly do under the Refugee Convention. I mean, no one has the right to protection when you are, you know, linked to mass atrocities committed by a regime you were working for. And that's a sort of an easy way out to sort of, yeah, comply with your duties under the ICC maybe, and do it the cheap way. I would not like to see that happening.
Yeah. Does any of our panel have a last comment to make? Because we're just after 6:15 now, and that's winding up time. Did Mike or Dove want to add an extra comment at all? No?
Yeah, I just have one very quick comment, which is that, you know, this whole doctrine and all the writing and all of the theorizing about universal jurisdiction, when we look at successes that are out there, which are not, you know, they're there, we tend to get some confirmation bias. And the beauty of both this panel and, boy, the rich discussion, you know, I'm looking at the names that are here. We know the real problems. And I just think it's incumbent upon us not to overlook the real problems and just to take the confirmation bias of the few cases that have been out there that have worked, where we've had the evidence, where we've had the alignment of the stars and the right criminal statute and the right prosecutor and all of that. We can't get complacent in just saying, okay, the system's fine, we're all there, which I think everybody on this call would kind of realize. So what a joy to spend time with people, and I appreciate people's time.
Thank you very much, Mike. And we've got to wind up now. The staff have to go home. Well, they're probably at home anyway running this, but they have to clock off. I'd like to thank my panel, Elies, Dove, Mike, for a great discussion this evening here in London, this morning in the US, and I know we've got a global audience, which is great to say these days. And this replaces our conference season. And I thank you for participating. That was a great evening. And I thank our guests for logging in and showing interest in the webinar. And I look forward to seeing everybody in the not too distant future, in the flesh rather than on a screen. Anyway, thank you very much and good evening to all of you. Good night.